Hello friends, Mandar here. I'm back with another video. This is the second in the series of the Policy Memo videos that I'm making. This memo came out on November 17th and it says use of discretion for the adjustment of status. So if you're interested in knowing about the changes in this Policy Memo alert for the adjustment of status adjudication process, then watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your personal immigration needs, you should hire a competent immigration attorney. With that said, let's get started. So USCIS issued another policy memo on November 17th to use the discretion for adjustment of status adjudication. The policy memo is the set of instructions that have been given to the USCIS officers when they do the adjudication of your adjustment of status. Now, adjustment of status is the final stage of your green card application. After this stage, once the adjustment of status is adjudicated, you get your actual green card. So this is kind of a big deal. The current administration is doing this towards the end of their term, and it's kind of come in as a surprise. Although I know that this has been in the work for the past several months or even years, this policy memo to come at this stage is a little bit of a surprise. But that said, let's look at what's actually changing in this policy. So first of all, I want to let you know when is this effective. So it is effective immediately. The memo clearly says that any changes proposed in this use of discretion for the adjustment of status is effective immediately. So if your application is in process as of November 17th and it has not been adjudicated yet, then this memo is applicable to you. Now what it means by the use of discretion is for USCIS officer to consider some positive points and to consider some negative points and collectively look at them. So the keywords that they have used in this policy memo are: the positive discretionary factors have to outweigh the negative discretionary factors in order to be able to determine the eligibility for adjustment of status. So USCIS wants the officers to use a discretion to look at the totality of these positive factors as well as negative factors and see which factors outweigh the other in order to make the adjudication. Now these factors include applicants' conduct, their characters, their ties to the United States, their immigration status, how well they have been maintaining their immigration status, their status history, and there are some other humanitarian concerns that are also included in these factors. And these all factors will collectively determine at the discretion of the visa officer whether or not to grant you the green card. The policy highlights it consolidates the guidance of the rights, privileges, and the responsibilities of the lawful permanent resident. And it also guides the officer to consider some factual evidences for the positive as well as negative factors in order to determine if they can adjudicate the case in a favorable manner. Now let's go look at the actual policy memo and see what is mentioned here. Now I'm going to highlight the key things that are important to you so that you don't have to read through the entire policy memo. I'm going to try my best to highlight them for you. Now here's the policy memo. Now here's the actual policy memo on the USCIS website. So it says Chapter 10 Legal Analysis and Use of Discretion. In the section A it says Burden of Proof and Standard of Proof. So if you come down, you will see that this adjustment of status provision involves discretion for all kinds of adjustment of status. So if it is family based, employment based, diversity visa adjustment, special immigrant based adjustment, traffic victim based adjustment, crime victim based adjustment, asylee adjustment, Cuban Adjustment Act, and so on and so forth. So basically all the adjustment of status petitions are covered under this policy memo. So now I'm just going to point out there is a lot of legal language in here, but what I'm going to go is this section of the memo which clearly outlines the positive factors and negative factors. So I'm just going to go as an overview. So On the left hand side, they have the issue, which states what kind of factor it is. The second column is the positive factors, and then the third column is negative factors. So from the eligibility requirement perspective, meet the eligibility requirements for adjustment of status. Obviously that is a positive factor, and not meeting the eligibility requirements is a negative factor, which doesn't tell us much unless we go into these links in. The second one is family and community ties. Now this is something important to read through. Family ties to the United States and the closeness of the underlying relationship. So if you have close family ties in the United States, that is considered a positive factor. Hardship to the applicant or close relative if the adjustment application is denied. So they will look at if they were to deny you the application or the green card, what is the hardship to the applicant or the close relatives that are already in the United States. So that is also a factor. Then the third factor is length of lawful residence in the United States, status held and conduct during that residence, particularly if the applicant began his or her residency at a young age. So they are going to give a positive, they are going to treat this as a positive factor if you have been in the United States as a lawful permanent resident for the long time. So if you came as a child as a lawful permanent resident, and if it has been more than 20 years, it is certainly a positive factor. Now if you have absence of any close family ties or community and residence ties in the United States, that will be considered a negative factor. Now I don't know how this will be used as a discretion unless you have some data points, unless they specify how many number of close relatives need to be there in the United States or things like that. So that is to be seen, but this will clearly be a concern for a lot of people. Now immigration status and history. So it tells the positive factor would be compliance with immigration laws, the condition of any immigration status held. So this clearly says that if you have been maintaining your immigration status or visa in the United States without falling out of status at any given time, then that is considered a positive factor. Violation of any immigration laws and conditions during your entire stay within the United States in the past several years is going to be held negative against you. Business and employment skills, property, investment or business ties in the United States will be seen as positive. Employment history, including the type, length and stability of the employment, is going to be a positive factor. Then if you have education, specialized skills, training, and that is also going to be a positive factor. So if you have been working in the United States or holding a business throughout your career, and if you have been paying taxes and things like that, that would definitely be considered a positive factor. If you had a significant unemployment period, or if you have been doing nothing for a long time, that could be considered as a negative factor as per the new memo. Community standing and moral character. So this is also a very important point. Respect for law and order, good moral character. So you should not have any criminal record, not have any significant police record or criminal activities. You should be paying your taxes on time, cooperating with the law enforcement authorities, community services and beyond. All of these will be considered as positive factors. As against if you have had an encounter with the law and significant things such as driving under influence or criminal record or any domestic violence, that is definitely going to be a negative factor. If you have not met your tax obligations or failed to pay child support, those will be considered as negative factor. And then the last one is absence of significant undesirable negative factors and other indicators of good moral characters. So this is going to be considered as positive, whereas other indicators adversely reflecting the applicant's character and undesirability as an lawful permanent resident of this country, that is going to be considered as a negative factor. So it clearly outlines what is the discretion that the visa officer has based on all of these points. So what can be considered as a positive factor versus the negative factor. So you can go through this. It's really in detail, and see if there are any concerns for you. If you have, so feel free to comment down in the comment section. What are your thoughts on this new policy memo? So all in all, it's reiterating the things that we have already known, except a few exceptions, such as you need to have family ties that are certainly being given a higher weightage as against in the past. So this memo is effective immediately. So I would highly recommend you to go through this memo and see and talk to your lawyer if you have any concerns regarding any of those discretionary factors that you may be worried about. So I hope you got value out of this video. If you have any questions or comments, please feel free to put them in the comment section below. So if you like this video, please hit the like button and consider subscribing to my channel, and I'll see you in the next one.